I am Professor Henry Gabriel from Elon University School of Law, and I am quite honored to be able to participate in this lecture series going along with the 40th anniversary of the CISG. What I'd like to cover this evening is some aspects of a contract or transnational contracts that are outside the CISG itself, but are very important to a contract for the sale of goods over a distance. And if I could, I'd like to, I always think it's useful to set up the situation that creates the need for what we're talking about. If we have a seller and a buyer, it's easy enough if a face-to-face transaction, the seller delivers some goods, buyer pays money. And that's your basic sales contract. And we assume it's a cash sale. That's our default rule in virtually all legal systems, including the CISG. Now, we could have a credit sale where the seller delivers the goods to the buyer, and the buyer pays the seller later. We could have a prepaid sale where the buyer pays for the goods in advance, and then the seller delivers the goods. But the general assumption in most sales contracts is that it's a cash sale. And the problem when we have sellers and buyers in different locations, as is often the case, or almost inevitably the case in a CISG contract, then the goods are going to have to be carried. They're going to have to be moved, to be transported. So we have a carrier. And what we can do by using certain documents, certain forms, certain legal instruments, is that we can replicate effectively a cash sale over distance. Because what we're going to see, what I'd like to discuss, is that when we deliver the goods to the carrier will produce a document, a bill of lading, that represents the right to the goods, the ownership to the goods, the title to the goods, and through some intermediaries, usually banks, so let's say the seller bank and the buyer bank, these documents can be transferred to the buyer, and the buyer pays for the goods and receives the documents. And that simultaneous exchange here replicates a cash sale because it is effectively a cash sale. And so this is the commercial transaction that we're talking about. Now, I think it's important, and let me point out that, say, this transaction here is your sale of goods. And that's probably a CISG contract, but the agreement with the carrier is going to be governed by other law. It's going to be governed by transport law. And the rights and obligations that flow through the delivery of these documents is going to be governed by a third series of laws. So it's always important, I think, to keep in mind that the whole transaction is governed by a variety of different laws. And so we want to keep that in mind. Now, if I can move over here, there are two major legal instruments that we want to talk about today. And they are bills of lading and letters of credit. These are very important legal instruments that go back a long time historically, and have developed over time to allow a fairly uniform usage throughout the world. What we're going to talk about with bills of lading is briefly going to introduce where did it come from? What's the source? We need to distinguish between negotiable and non-negotiable bills of lading. We'll go over that. And then discuss how the bill of lading fits within the overall sales contract that we'll be talking about. Also, I want to mention some other types of transport documents: Seaway bills, consignment notes, and some other transport documents, and because they're very common in how they fit within the scheme of these commercial transactions and how they differ from a negotiable bill of lading. The second type of instrument that I want to talk about is a letter of credit. A letter of credit is a venerable old legal instrument. Some people suggest that it goes all the way back to the Babylonians. I think that's fairly questionable, but certainly in Renaissance Italy, the letter of credit was fairly well developed, and its use has continued since then. So we'll go through the basics of letter of credit, the relevant parties, the rights and obligations, and how the letter of credit fits within this payment mechanism. Now, starting with the bill of lading, historically, the concept of a bill of lading goes way back. And see here, receptum natarum. That's a Roman concept. It creates a carrier liability, and there was a similar liability for innkeepers, stable keepers, for example. But for hundreds of years, going back to a Roman law, the law recognized a strict liability obligation on the part of a bailee, someone holding someone else's goods, either for storage or for delivery. You see here the Ordonnance de Marine. This is a French statute from 1681 that sort of codified the notion of the bills of lading, what we're going to talk about, and the concept of bills of lading in its present form got received into the common law, mostly through the law merchant, the merchant's law that the case law absorbed. And so certainly by the 18th century, late 18th century, the law that we now recognize as bills of lading has been recognized uniformly, universally. So this creature goes back historically for a long time. Here's one. There's a modern bill of lading. You can see, fill in the blanks. It describes the goods that are going to be shipped. It's got lots and lots and lots of terms and conditions, and we'll discuss why that becomes necessary. Now, where does this bill of lading come from? And I mentioned this, but we want to keep in mind that the bill of lading is issued by the carrier when the carrier receives the goods. Okay, and it's probably useful if I define some terms here for us. The carrier, the party that's actually transporting the goods, is the carrier. That's the carrier. So that's going to be the transport company. The shipping company is not the shipper, it's the carrier. The shipper is the party that enters into the agreement with the carrier to ship the goods to the consignee. So generally with our CISG type of contract, the seller is going to be the shipper, or sometimes referred to as consignor, because the shipper consigns the goods to the carrier to deliver to the consignee, which is likely to be our buyer. Now, I point out that the actual arrangement with carriers is often done by agents, freight forwarders, or logistics companies, or some agent of the seller. But for purposes of our discussion, we'll just treat the seller as being the shipper for these transactions. It's and that will keep us sort of straight with our language here. Now, this bill of lading serves a couple of functions, and a bill of lading is one of two things, or it's at least one thing and maybe two things. A bill of lading is an agreement between the shipper and the carrier, and it's just a contract in essence, that agreement. So it'll be governed by the terms and conditions of that contract. So bills of lading are inevitably going to be governed by contract. But a negotiable bill of lading is also creates separate rights. So a negotiable bill of lading, and we're going to distinguish a straight bill of lading, which is a non-negotiable bill of lading, which is merely the contract rights between the parties, and negotiable bill of lading, which allows the possessor of the bill of lading, physically the bill of lading, to transfer rights to the goods. But what does this bill of lading do? We deliver the goods to the carrier. The bill of lading gives the consignor, if it's a non-negotiable bill of lading, or the holder, the person having possession, if it's a negotiable, the right to instruct the carrier. Right to instruct the carrier to do what? And that is to deliver the goods to where the seller shipper wants the goods delivered. Inevitably, that turns out to be the buyer. There may be some problems along the way, a disagreement between the seller and the buyer. There may be some problems, and the bill of lading allows the goods to be stopped in transit. So the rightful right holder of the bill of lading can have the goods stopped in transit by the carrier. Because with a negotiable bill of lading, and we'll come back in a bit and describing in more detail those rights, but with a negotiable bill of lading, the bill of lading actually represents the rights to the goods, the title to the goods, and the goods can be sold in transit. And I'll give you a very common example. A tanker full of oil that's crossing the ocean, say crossing the Atlantic Ocean, is often sold a half a dozen times during its transit. So the original owner of the tanker, of the oil itself in the tanker, can sell it to someone else, and then someone else, and someone else. And those successive sales are accomplished by transferring the bill of lading, and that transfers the ownership. Also, because bills of lading represent the right and title to the goods, that means that the person with the bill of lading can use that bill of lading as collateral for a loan. And we see the same event happening, for example, when goods are stored in a warehouse, and a warehouse receipt, which is very similar to a bill of lading, except where a bill of lading is issued for goods being transported, a warehouse receipt is issued for goods staying in a certain same place in a warehouse. You can transfer the ownership by transferring the piece of paper. Now, here are some common sources of international law that covers bills of lading. And we see, interestingly enough, these are all conventions dealing with the shipment of goods, carriage of goods. And we got the Hague Rules. 86 countries have ratified the Hague Bisbee and the Hamburg Rules. The most recent iteration of international transport law is the new Rotterdam Rules, and you see that there's only been 3 ratifications thus far. I'm hoping there'll be more ratifications. Interestingly enough, and I think this is very important with the Rotterdam Rules, is that the Rotterdam Rules actually recognize modern commercial practice, which is that one can use electronic bills of lading as opposed to the traditional paper bills of lading. And I think that's important to keep in mind because as we discuss bills of lading, we're going to primarily talk about how they function within the world of paper. But do keep in mind that as with many things today, we can do electronically what used to be done with paper. Now, I say paper, and this is important to keep in mind because a bill of lading, and we saw a sample there, a bill of lading is a piece of paper. And the way that one transfers the rights traditionally is you take the piece of paper and you transfer the piece of paper. And the transfer of the piece of paper transfers the rights. Now, what do I mean by rights? And what I mean by rights is that we sort of reify the goods themselves into the piece of paper. Instead of having to have physical possession of goods, physical possession of the piece of paper constitutes the legal right to physical possession of the goods. It constitutes title to the goods. It's much easier to transfer a piece of paper than it is a bulk of goods. Now let me come back to our slides here. The most useful type of bill of lading, I suggest, is the negotiable bill of lading, because that allows the transfer of the ownership and rights by the transfer of a piece of paper. And that means that the person having possession of the paper, the person we refer to as the holder, can control the delivery of the goods. But there are non-negotiable bills of lading, which we call straight bills of lading, often referred to as straight bills of lading, and they only represent the underlying contract right, and therefore the piece of paper itself is not significant or necessary for the transfer of the rights. Carriers often prefer straight bills of lading because if you think back of that little transaction I mentioned in the very beginning, where we transfer these documents and some bank at one end will present the documents to the buyer. It is essential to appreciate that when there's a negotiable bill of lading, a carrier will not deliver the goods to someone that does not have that piece of paper. If the carrier does deliver the goods to a party that does not present the bill of lading, then the carrier assumes liability for any loss, destruction of the goods. So carriers will not do that. Now, of course, the problem is that you have to make sure that those documents get to the buyer before the goods do, so that the buyer can show up and get the goods from the carrier. So carriers don't necessarily like to assume that risk that the buyer will in fact have those documents. But it's a useful part of our commercial transaction, because again, What this allows sellers and buyers to do is to use the goods as a way of transferring title, as well as for security rights, for loans and this, that, and the other, without actually having the physical possession of the goods. And I mentioned the right to claim delivery. That's the key function of a negotiable bill of lading, is that the person having the goods has the right to take possession of the goods. If we look at, and this is, I don't expect you to read all of this, just look at, and this is a classic English Privy Council case. This part here, it's perfectly clear that a ship owner who delivers without production of the bill of lading does at his own peril. That is the principle that we have to appreciate. And that is, if we're dealing with negotiable bills of lading, if we're dealing with a document, a negotiable document, that's the bill of lading, the carrier will only turn over those goods if that person has that document. Now, I mentioned a bit ago, and we want to come back to this point, and that is that our bill of lading functions in two ways. There's the underlying contractual agreement that goes with the bill of lading. Then there's the additional aspect of negotiability with a negotiable bill of lading. But I'd like to spend a few minutes talking about this first function. We want to keep in mind that whether a bill of lading is negotiable or non-negotiable, it does serve a contract function. And what functions are those? You know, if we go back here, okay, back to this bill of lading that we were looking at. There you go. There you go. Standard terms and conditions with a few other things thrown in. Carriers assume if the goods are in transit, they have basic strict liability. There's a lot of liability there, and then so there's the question of, well, what if, and what are the limits of my liability? And there are a lot of other laws out there that will limit the actual dollar amount, the monetary amount of liability. But when the carrier takes control of the goods and has possession of the goods, the carrier has a lot of liability and has to safeguard the goods, take reasonable, more than reasonable care of the goods, and has to deliver them to the consignee, the buyer. So it has that obligation of actual delivery. There are going to be a tremendous amount of other obligations if we think about international commercial law. How do we get the goods out of country A? We have customs, we have inspections. How do we get the goods into country B? We have customs, we have inspections. We may have all sorts of health concerns, safety concerns. There are a tremendous amount of obligations that go with the transport of goods, other than the mere physical transfer of the goods. And those obligations are going to be set out in the agreement. They're going to be set out in the contract of carriage. So irrespective of what other obligations the carrier may have with the goods, they're certainly going to have a lot of contractual obligations, and they're going to be set out in the contract for carriage. Often there's a charter party. We don't just hand it over to the, a carrier may or may not own the vessel, and all those complications and levels of rights and ownership that go with commercial maritime transport. They're probably going to be laid out in the bill of lading as well, as they need to be. there will be third-party rights. There will be third-party rights. Essentially, even with a non-negotiable bill of lading, the buyer, the consignee, the person to whom the goods will go, will have rights. Now, where are those rights going to come from? Well, because the underlying contract for a bill of lading is between the shipper, usually the seller in our situation, and the carrier, those contract rights are going to be laid out with great specificity between those two parties. But how about the consignee, the party getting the goods? Well, to the extent that that party has rights, and they're likely to have rights, they're either going to have rights as a third party, expected third party of the contract, or the bill of lading as a contract could be assigned to the consignee, in which case the third party would have direct contractual rights under the original agreement. But knowing that there is some third party out there, the party to whom the goods will be delivered, there are a lot of questions that a carrier is going to have. Who's going to pay, or how are the goods going to be transported from the carrier, from the boat, for example, to another common carrier, wherever the goods are going to go? How is the buyer going to pick up those goods? What if they're port fees? There are a lot of issues, very complicated issues that go into these transport contracts, and they will be inevitably laid out with the contract as well. And so we think in terms of limitations of the rights that a third party might have, because again, any third party rights will inevitably have to be in the underlying contract, will have to be in the contract itself. So all of this, and to a large extent, even though there are a tremendous number of legal issues there, they're fairly standardized these days. The shipping of goods by common carriers, so common and has been for hundreds of years, that most of the issues that arise will have been resolved in their set out form contracts. If we look at this slide here, it lays out the major contract functions of the parties. Even though bills of lading are governed by contract, an underlying contract, and again, there may be negotiability on top of that. There are statutes, for example, the Carriage of Goods and Sea Act here, which is used as an example, that lays out the basic contractual structure between the parties. Now, it's interesting here, the lawful holder of the bill of lading. When we get to the question of a negotiable bill of lading, we'll see that in the case of a negotiable bill of lading, the person, the holder, and that's the term we use, it's not surprisingly, the English term holder, for purposes of what we're talking about, is derived from the word hold, right? The person actually holding the document. They have certain rights.
Harriet, that's a good verb for me to step in. Hold on, because you're not sharing your screen.
Oh, I apologize. Okay, so screen two. This one.
Yes. Yes, thank you.
Okay, I'm sorry. Okay, good. What I hope came across was, even though we're talking about often the underlying contract rights, much of this is governed by either domestic or statute or international convention that lays out some of the basic the structure of the underlying contract rights. And as I was saying here, we're dealing with a negotiable bill of lading, because in that case, the rights are derived from the party that has it. But in the case of a non-negotiable bill of lading, which, for example, a Seaway bill, I'll mention that later, that's a non-negotiable bill of lading. The party may have rights. Now, this is the person who delivered the goods. The Seaway bill is to be made by the carrier in accordance to the contract. Well, why would that party have rights if they're not a party to the contract? And what this provision does is it creates statutorily a third party right. It says that even though you're not a party, a contracting party to the bill of lading, it is understood that you will have certain rights as a third party beneficiary. Or in the case, the person whom delivery is may transfer to him vested all the rights under the contract. This presupposes the possibility, again, of contract rights being assigned, so that, interestingly enough, the law recognizes two ways that parties might have rights if they're not a party to the original contract. That the contract presupposes they have rights as a third party beneficiary, or that the rights may in fact be transferred. And this just restates that point, that it is recognized that parties have rights. Now, I do want to emphasize, though, that if a party's only with a non-negotiable bill of lading relying on the contractual rights, then the rights will not be based on having the piece of paper itself, because the piece of paper is not necessary for a non-negotiable bill of lading. Now, this is what I think are the guts of bill of lading law, and that is in the case of a negotiable bill of lading. And I often think it's useful for folks that are not familiar with negotiable documents to think in terms of negotiable instruments. And I'm throwing out big terms that I'm going to define for you. But if you think of a check, which used to be very common, but is less common today, but we all know how a check works, right? And that is that if I write you a check for a certain amount of money, you can take that to a bank and you can cash the check, you can negotiate it, you can pass it on. But the piece of paper itself represents the rights to the money. And we call those instruments. So those are negotiable instruments. And a negotiable instrument is a piece of paper, in these days, the electronic equivalent, but a piece of paper that represents the right to money. And I think we all understand how a basic check works. Well, in the world of negotiable documents, it's basically the same thing, except that the piece of paper doesn't represent the right to money, it represents the right to goods. And so in the way that a check is negotiable, in the sense that you can take it and negotiate it, you can transfer it for the money, a negotiable document does the same thing. The piece of paper entitles you to the goods. And a bill of lading is merely one type of a negotiable document. But what does that mean? It means that with a negotiable bill of lading, that the person who has the piece of paper has the property rights. They have the title to the goods, okay? And they can transfer the goods. They have constructive possession. And I think that's a very important point for us to keep in mind. And that is, if I have the piece of paper, it is the same as having possession. in the same way that if we have a check, and again, I think we're all familiar with checks, the way to transfer a check, if you go to a bank and say, I want to cash the check, they say, well, turn it over and endorse it. You need a signature, you need an endorsement. And it's the same thing with a bill of lading. And so where someone has the piece of paper, the bill of lading with the proper endorsements, and the endorsement is going to be from the person who has rightful possession of the bill of lading will endorse it, and they can transfer it over. That transfers the title of the goods, the right of possession, and it beats out third-party rights. And this is, again, a very important principle here, that generally speaking, the person with a bill of lading has superior rights to someone else who may have rights in the goods. And that's a very important commercial function, because bills of lading are transferred and sold, and people, banks loan money on them, take them as collateral. And so in order to make bills of lading commercially viable, they have to be able to be transferred without regard to the possibility of someone else saying, I have not a right in the bill of lading per se, but I have a right in the goods that the bill of lading represents. So as a general proposition, a person that has a negotiable bill of lading has the title to the goods, the right of possession to the goods, and those rights are superior to other parties that may have some right in the goods themselves. Here's another case quote. Nice little longish quote here. What it tells us is what I hope we've appreciated already, and that is that the endorsement and delivery of the bill of lading represents the delivery of the goods themselves. So that's how we transfer the rights in the goods. And again, just to keep our eye on what we're, our ultimate goal here, we keep in mind that when the seller has that bill of lading transferred to the buyer, and the buyer has to pay for the bill of lading before the buyer has access rights to the goods, that the buyer has effectively purchased the goods. And that way we can have a commercial transaction where we're transferring title and rights to goods, irrespective of where the goods are at any given time. So we don't. So the whole transfer of title is going to be based on the transfer of that document here. These original slides were put together by Angelo, and he conveniently put this one in. And I love this slide because I don't speak German and I have absolutely no idea what it says. But I have a rough notion that it probably says that the possessor of the bill of lading has rights and title to the goods. It may say something else. It may be an invitation to a party, but I'm not sure. But I do think it probably says what I just suggested it said. We want to keep in mind also, and that the bills of lading here function within the here we go. That the bill of lading functions separate from, but within the context of our sales contract. So we've got our seller here, and our our buyer. And the goods are being moved somewhere, being moved. In this transaction, the contract for carriage and the issuance of the bill of lading is governed by whatever law governs bills of lading and contracts of carriage. But there is this separate agreement. I'll spell out contract between the buyer and seller. Well,
Henry, we can't see your whiteboard either.
oh, see the whiteboard? Okay. You are screen sharing. Share. There we go. See it now?
Yes.
Sorry about that. There's this the pushing of the second button that I keep forgetting. So what I was just saying is we've got our seller and buyer, and there's going to be a contract for sale here, and then we're going to have separate obligations here. But if I can control the bill of lading, I can control problems here to a certain extent. Now, the contract for sale itself might either specify or it may be implicit that the seller is going to ship the goods by common carrier. So the contract will require either expressly or specific or implicitly that there will be a bill of lading. But what if there's a problem here with the buyer's ability to pay or some other problems so that we don't want the goods to be delivered to the buyer? Well, as long as the seller or the seller's agents have control of the bill of lading, they can control what the carrier does with the goods, so we can stop the goods in transit. Or if it's determined not to go to the buyer, then the seller can resell the goods. By simply reselling or selling the bill of lading to someone else. So that is some of the rights here. Let me screen share. So those are some of the rights here that the seller retains by retaining possession of possession or constructive possession. I say possession or constructive possession. The bill of lading is inevitably going to be passed along through the chain of banks or other intermediaries for delivery to the buyer. But those parties are effectively agents of the seller. So the seller can control the movement and delivery of the goods. Now, these things, what happens when there are charges that pop up that the carrier has that have not been met? And of course, this is going to be in the contract for carriage, the underlying contract itself. And all those terms and conditions we discussed earlier are going to allow the carrier the contractual right for those payments or withhold delivery of the goods if necessary. Here's another wonderful case quote. When a man sells goods, he sells them on the credit of the buyer. If he delivers the goods, the property is altered. If I sell you goods on credit and you're not in an ability to pay for the goods, then that's my problem as the seller. And that's the problem with a credit sale. Where we want to go with this is the advantage of the bill of lading is that we can avoid the inability of the buyer to pay once the goods have been transferred, because if we can control the possession of the bill of lading, then the buyer cannot get possession of the goods until the buyer has paid. Going back to the point I think I made initially, which is what we're going to do is effectively create a cash sale over long distance and avoid a credit sale, avoid sending our goods halfway around the world to be delivered to a buyer who turns up unable to pay. So this is how we avoid that. This is sort of the whole underlying point of the use of bills of lading. Now, ever since, I'm gonna reach over here. You can't see me. But what I'm going to say now becomes a bit more important today than it might have been in earlier times. And that is this. It is common. What I went and grabbed was my copy of this, the book, the box. What this book is, a history of standard shipping containers. It's a fascinating book for people like me that find things like that fascinating. But if you think about it, one of the modern inventions in transport of goods is the standardized shipping container, where a factory or warehouse can put goods in a shipping container, put it on the back of a truck takes it to the train takes it to the boat goes across the ocean, puts it on another truck and delivers it. And this multimodal, this movement of goods very quickly in these standardized containers. Well, it has made shipping tremendously cheap, and it costs less to ship goods across the ocean than it does to get it from the nearest port to where I am to here. Shipping is so with the bill of lading, we need to keep in mind that the paper, the bill itself, will specify precisely what goods are delivered to the carrier. And because the holder, the purchaser, maybe ultimately the buyer, but some bank or intermediary will rely on that bill of lading for purposes of determining what the collateral is, what the goods are. If the description on the bill of lading varies from the actual goods there, it's called a misdescription. It's a very accurate term. The carrier is liable for that. So often what happens, particularly with standardized containers, is that the bill of lading will have some exclusions, like, now, there we go. The bill of lading will say quantity of the goods. They'll state the condition of the goods. Okay, that will be in the bill of lading. But often, and this is particularly the case with shipping containers, where the shipper, the seller, actually is in charge of loading the goods in the container. When the bill of lading is issued, the bill of lading may say, said to contain, shipper's load and count, which is the carrier's way of saying, we didn't count how many tractors are in there. You know, we didn't actually weigh these goods. So these exclusions that are common in a bill of lading represent the ability of the carrier to limit the carrier's liability for the description of the goods by saying, you rely on the shipper's description. We're not verifying that because we were not in a position to verify that. We did not open up those containers and see if everything was in there as described. And with modern boats carrying up to 10,000 standardized containers, when the carriers are issuing these bills of lading, it's often difficult, if not impossible, to verify the contents of these containers. So it is very common these days. It's been common for many years, but even more common these days with standardized shipping containers, for the bill of lading to have these reservations. In other words, said to contain. Shipper tells us it contains that. Now, this should not be misleading to anyone relying on the bill of lading, because they can read the bill of lading and see that it actually says, here are the limitations and whatnot. But it's a way of the carrier avoiding the strict liability, the effectively absolute liability of the goods being in the condition, the quantity and quality that are specified. Here's an example of that. In apparent good order and condition. We're not promising. We're not promising. Cargo is specified. You know, here's all the sort of standard language. Shipper packed. We didn't pack the containers. The shipper did. So those are very common exclusions that carriers are going to make for the obvious reason that the carrier needs to make those. Now, the standard negotiable bill of lading is still a very important commercial tool. However, its utility may be somewhat lessened these days. Let me see. I'll show you why. Traditionally, we had our seller here and our buyer here, and the goods are going by common carrier, okay? And the seller could go to the seller's bank to actually handle the documents, all the paperwork. Banks do this. Send them over to the buyer's bank. There may be various other intermediaries. It's easier just to say this, and then deliver the documents to the buyer. But if you think about it, this presupposes that all of these documents are going to get there before the goods get there, because carriers do not like to be sitting on goods here at the buyer's end at this port waiting for these documents. Now, traditionally, the transfer of these documents was a lot quicker than that, and today the transfers of these documents is even quicker because so much of it's done electronically that it's almost instantaneous. But carriers do not necessarily like to assume now they get paid for it, obviously, but they don't like to assume the risk that somebody here is going to have the documents. And it could be not just the transfer of the documents is not done in a timely manner, but if the seller and the buyer in their contract or otherwise are having a dispute, having a fight, then the buyer might not get the documents anyway. Maybe the buyer can't pay. We're going to come back and see in a few minutes when we get to letters of credit how we might alleviate that risk. But there are a lot of reasons, particularly with low value items, where carriers simply do not want to assume all the administrative hassle and cost of dealing with bills of lading, and so they'll use there'll be a non-bill of lading. Go to FedEx and send a small package to me, and it's not going to be sent with a negotiable bill of lading. I'm pretty sure. So what we have is a variety of bills of lading that are not negotiable, and airway bills. That's what you're going to see in your FedEx package. Seaway bills and airway bills. If you see these terms, they inevitably represent non-negotiable bills of lading, straight bills of lading, and they serve a different function. They basically lay out the obligations that the carrier has to the shipper and to the consignee for the quality of the goods, the delivery of the goods. But these are situations where the carrier is not, and the parties obviously don't expect the carrier is not assuming the obligation that someone will actually have the piece of paper. The world, the world is not simply negotiable and non-negotiable bills of lading. For example, consignment notes under some legal regimes are sort of halfway in between a negotiable and a non-negotiable bill of lading, because consignment notes, certainly under, say, the CMR, the consignee has certain statutory convention rights for delivery in the underlying contract. The rights are actually beyond contractual rights, and so there's sort of an intermediate status between negotiable and non-negotiable. Here are some, and you see some international conventions that deal with these non-negotiable bills of lading, which are very, very common. In some transactions these days, the carrier functions is the financier as well. So we see a tendency in some, for what would have been traditional uses of bills of lading, that it's not necessary because, for example, FedEx, I use FedEx as an example, FedEx will not only transport the goods, but they'll handle all the financing, they'll handle all the paperwork. And so that negates the need for a bill of lading, because they're handling all those functions themselves. And to the extent that carriage companies can do that, I think we'll see more of that. And a company like FedEx loves it because it allows them to make more money. So, for example, with Nike sneakers, which are very popular here in the US, and they're made in Asia, and the Nike Corporation, the Nike company's never seen a sneaker. FedEx picks them up from the factory, FedEx boxes them, FedEx ships them to FedEx warehouses in the US, and FedEx delivers them to stores in the United States, and FedEx collects the money all along the way. So that they've sort of, it's a one-stop shop. And I suspect over the next decade or so, we're going to see more and more of that. And so it could be that the use of these various transport documents may lessen in importance. Now, what I want to do, actually, what I would like to do, and therefore I'm going to do it, is I'm going to take about a 10-minute break. That'll give you guys a chance to catch your breath and do what you want. And it'll also, and I think more importantly to me, give me a chance to catch my breath. So I'm going to pause for about 10 minutes, and then we're going to come back, and I'm going to explain to you how, we'll start with letters of credit, explain to you how that works and how that fits in with our transaction. So let me take a couple minute break, get myself a cup of tea, and I'll be right back. All right? What we want to talk about are letters of credit. But before we get into letters of credit, I want to sort of walk through how just a garden variety shipping transaction will work. Sell a goods shipping transaction. will work so we can see how this letter of credit device that we're going to talk about fits in. We have to appreciate we've got our seller and our buyer. And they've got a contract, okay? So they have a contract, sell of goods. And the seller is going to deliver the goods to the carrier, who's inevitably going to deliver them to the buyer. And that's carrier. Okay. And there are a few things that we're going to worry about here in the contract. One is that as a normal proposition, once the seller has delivered the goods to the carrier and they're on their way, the risk of loss, if the goods are damaged or lost, somebody may have an action against the carrier. But as between the seller and the buyer, usually the risk of loss is on the buyer. And there are historical reasons for that. And the parties can change that risk of loss, but normally it's going to be on the buyer. So like the seller is going to send this bill of lading through the channels. But if the goods are damaged or lost, it's going to be the buyer's problem. So the buyer probably wants insurance. So not only are we going to have a bill of lading, but we're going to have an insurance policy. So there'll be an insurance certificate guaranteeing the goods if they're damaged. And then there's another problem, and that is that normally, if I'm going to buy goods from you, under most legal systems, and certainly under the CISG, I have a right to inspect the goods before I accept the goods and pay for them. That doesn't work in the transaction we're talking about because the buyer cannot inspect the goods because the carrier, under bill of lading law, will not let the buyer inspect the goods until the buyer turns over the bill of lading, which the buyer has to pay for. So maybe we're going to have an independent inspection. So we're going to have a certificate of inspection to guarantee the quality of the goods because the buyer has to buy them sight unseen. So that's another problem that we may have to resolve in all these documents. And then there may be custom certificates because we got to get them in and out of countries. So we have custom certificates. And it is not unusual that along with this bill of lading, there's going to be somewhere between 20 and 25 documents of various forms, a whole lot of. And traditionally, one of the documents that would go along is a bill of exchange, a payment mechanism. In other words, that would be the device where the buyer would actually pay back. And bills of exchange are wonderful, wonderful historical commercial tool that is worthy as a lecture, but we're not going to get into that today. But so we have this situation where the buyer wants to reduce the buyer's risk as much as possible because the buyer is going to have to pay for the goods by buying the bill of lading before the buyer can see the goods. The buyer has to pay for the bill of lading before the buyer may even know whether the goods have arrived. So maybe they got lost, maybe they're not conforming, so we have some third party inspect it, insurance, we have all of these different things. And that reduces the buyer's risk to a certain extent. And so, but the seller in our hypothetical is hanging on a big risk. And the big risk is the risk of payment. because when the goods get here and the bill of lading gets here, the buyer has to pay for the bill of lading to get the goods. Well, there are a lot of reasons why buyers won't pay. The two most common is they can't, or they decide not to. But in either case, we have a situation where the buyer is not paying for the goods by paying for the bill of lading, and all these documents, the banks will send all these documents back to the seller and say, we presented the buyer in the presentation, we presented those documents to the buyer refused to pay, or the buyer couldn't pay. And so now the seller's sitting back here with a bill of lading, which means that the seller has never transferred title. Those goods that the seller shipped still belong to the seller. Seller can resell them, can sell them, do anything the seller wants, except that the goods are over here. And if I'm sitting here in North Carolina with a bill of lading for my goods who've been delivered to a port of Rotterdam, it's not the best situation, right? Because now I've got this carrier that's haranguing me and saying, oh, by the way, your goods are sitting here in our warehouse in Rotterdam. And we're, of course, running up the storage fees as well. They should and can. And what would you have us do with these goods? And that's just not what the seller wants. So what we're going to do is we're going to shift the risk of payment from the buyer and guarantee that the seller gets paid. And the way we're going to do this is we're going to use a letter of credit. Now, if we guarantee that the seller gets paid, irrespective of what the buyer does, we've shifted another risk, and that is that if we can guarantee that the seller is going to get paid, irrespective of whether the buyer performs or not, we do shift one risk, and this is the great unallocated risk, and that is that the buyer assumes the risk of the quality of the goods, because the seller is going to get paid anyway. Now, we may have resolved that by having some third party inspect the goods before they're shipped, but we'll come back to that. But what we want to do here is we want to guarantee that the seller gets paid, and we're going to use this wonderful little creature called the letter of credit. Now, a letter of credit is not a negotiable instrument. It's not like a check or a promissory note. A letter of credit is not a negotiable document. It's not like a bill of lading. It's not something that you can take and transfer the piece of paper. And it is not a contract. A letter of credit is a letter of credit. And I think it's always important to keep in mind that letters of credit are their own legal device. And you can't say, well, it's like a contract. It's not really like a contract because it's different from any other instrument. And the letter of credit, you can see here on this slide here, a couple of things that we'll come back to. The independence principle and strict compliance. Strict compliance. I want you just to make note of that. The independence principle is often called the autonomy principle. So if you see the term within the law of letters of credit, you see the autonomy principle. It's the same thing as the independence principle and strict compliance. And those are two of the sort of basic norms of letter of credit law. Now, this is how our basic letter of credit is going to function. And And I'm going to okay. You have my white, this is the whiteboard, I hope. A letter of credit is a three-party instrument. Three parties. There's going to be the applicant. There's going to be the issuer. And there's going to be the beneficiary. And the reason I'm putting them where they are is because it works well for a sales hypothetical. Now, the issuer does not have to be the same bank that would normally be presenting the buyer with the documents, but normally it is, and we'll see how this works. So what we're going to have is the applicant is going to be our buyer. The beneficiary is going to be our seller. And they're going to have a contract for the sale of goods. And what this letter of credit says is that, and a letter of credit is they look like letters. That's what it is. And the letter of credit is something that the issuer makes. So the applicant goes to the issuer and says, I want a letter of credit in favor of this beneficiary. What the letter of credit will say is, if you deliver these documents to us in this form, we will pay. And what that does is it shifts the risk of worrying about the buyer paying. So I don't have to worry about that. That's the worry only that the issuer will pay. And the issuer is inevitably going to be a reputable bank. So instead of worrying whether the buyer can or will pay, the letter of credit will shift the risk from the buyer paying under the contract to the issuing bank. And that ameliorates a lot of the risk. Now, so if I've got the buyer in Vienna, I got the seller in North Carolina, and I'm using a Vienna bank, that means our seller has to deliver documents here to this bank, and the bank will pay. And what documents are we talking about? It's going to be the bill of lading. It's going to be insurance certificates. It's going to be the certificate of inspection, or all of those documents that you would normally deliver to the buyer, you deliver here, and the issuer pays. Okay. And that's all well and good. But the problem, if I'm sitting here, is that I've got to deal with a bank here, which may be inconvenient. So what's going to happen is that this Vienna bank is going to have a correspondent relationship. The entire world is connected with these webs of corresponding relationships. So that means that there will be some local bank here in North Carolina, local bank, that will handle the paperwork for the Vienna bank. So what will happen is that, this will go out, the seller will get a letter from the local bank saying, if you deliver these goods to these documents to us, we will handle the paperwork to get those documents to Vienna so that the issuer will pay you. And if in that letter here from the local bank is an advising letter, and that means that this bank is advising the beneficiary of the letter of credit and that they'll handle the paperwork. But this bank can also assume not only an advising capacity. They can confirm. I'm going to show you some slides in a minute that lay this out. They can confirm the letter of credit. Now, what that means is that by confirming the letter of credit, they assume the liability of the issuing bank. It's as if they issued the letter of credit itself. Now, banks love letters of credit. They love letters of credit because they're very low risk. And because they're very low risk and they ain't cheap, they make a nice profit. So banks love to issue letters of credit as long as everything is in order. And banks do not, without proper legal reasons, decline payment on letters of credit. And that's because the banks of the world are all work together. And if you are a bank that doesn't pay on a letter of credit without a legitimate reason for paying it, then you're getting thrown out of the system. Nobody will deal with you. Banks pay on letters of credit. Now, our buyer here gets a local bank to issue the letter of credit. Now, this bank is in a position to evaluate the credit worthiness of this buyer. They may trust the credit of the buyer because they know the buyer, or they may ask the buyer for some security or some guarantee of payment. But as between the buyer and the issuing bank, that's fairly low risk because the issuer is in a position to evaluate that risk. This bank will confirm this letter of credit because the only risk a confirming bank has is that this bank literally goes insolvent. Okay, that's really the only excuse for not paying. So this is very low risk. So they'll confirm. Now, the seller getting a confirmation from a local bank that guarantees payment on the letter of credit only has the risk that this bank cannot pay. And that generally with a major bank is just not a risk. So that means that we have taken the risk of the buyer paying the seller, the buyer being halfway around the world, and we have broken that risk down into little bite-sized risk of which no one takes on more risk than is reasonable under the circumstance. And that, I hope you follow that, because that is this. That is this. And so my little scribble on the board is a way of showing you how this works, where we've got the applicant, which is the buyer, in a contract with the seller. And instead of the seller having to worry about the buyer paying, the buyer goes to the buyer's issuing bank, get a letter of credit, has the confirming bank confirm. And so the seller delivers the documents to the confirming bank. The confirming bank pays the seller. The confirming bank shifts the documents to the issuing bank, who pays the confirming bank. And the issuing bank delivers the bill of lading, whatever necessary documents, to the buyer, and the buyer pays off. That's your basic letter of credit transaction. Now, the issuance of the letter of credit is inevitably, well, the requirement of the letter of credit is going to be in the contract between the buyer and the seller. Okay, is that so? Why does our applicant buyer get the letter of credit? And the answer is because the contract requires the letter of credit. And we can see why the seller wants the letter of credit. And the seller is not going to ship the goods to the buyer until the seller knows, until the issuer has issued the letter of credit and the seller is aware of that. You know, the timing there is very important because until we have the letter of credit, the goods will not be shipped. And that's our major function here of shifting risk, and that's the major function of our letter of credit and our basic transaction here, is to shift the risk of payment or risk of non-payment. So we're talking about from the buyer, maybe halfway around the world, to a reputable bank, and preferably a local reputable bank. Now, I mentioned that there are two basic principles here. One is the principle of strict compliance. And what that means in a nutshell is that the beneficiary has to strictly comply with the terms of the letter of credit. So if the letter of credit says we need this bill of lading, this insurance certificate, blah, 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 and we need it by a certain date in a certain form, any deviation from that gives the issuing bank the right to deny payment. So the doctrine of strict compliance it's been built in, it's been baked into letter of credit law for as long as anyone can remember. The other principle is the autonomy principle, the independence principle. And that is that the obligation to pay on the letter of credit is independent of the underlying transaction that is the basis for the letter of credit being issued in the first place. Okay, so let me go back here. There we go. All right, so see, many things can go wrong. So we've got our seller here and our buyer here. We've got our issuing bank, and we'll just throw a confirming bank in just for the fun of it. Okay, so letter of credit. Letter of credit says you deliver these documents in this form and we will pay. We will pay. Okay, so let's assume that the goods are being shipped by carrier and the boat sinks. The boat sinks. The buyer is not going to get those goods. Buyer contacts the bank and says, boat sank, we're never going to receive the goods. Don't pay on the letter of credit. The issuing bank's going to say, you know what? We don't care. We don't care. It's not our problem. You can sue your insurance company. You can sue the carrier if they're at fault. If it's the seller's fault, you can sue them. But our obligation to pay on the letter of credit is independent of any other problems. That's what makes letters of credit so useful. That's what makes letters of credit so useful. The buyer and seller may have a contractual fight. The goods may get to the buyer. The goods may be non-conforming. The goods may, there may be some problems with the goods. That gives the buyer the right, of course, to sue the seller on the contract. But the seller's already been paid. The seller's already been paid. So any fight we have between the seller and the buyer, or the seller or buyer against the carrier, those are legitimate claims if there's a basis for the claim. But our issuing bank, our bank doesn't care, because the obligation to pay on the letter of credit is independent of any other legal problem or dispute. Okay, so that is, those are our two basic principles. the independence principle, and the doctrine of strict compliance. The underlying contract may have requirements separate from the letter of credit. When we go back to these bills of lading, when the seller's agent delivers the goods to the carrier, there may not be a vessel available at that time. So the carrier is storing the goods until there's an available carrier. They'll issue the bill of lading, but it'll be a delivery bill of lading as opposed to an on-board bill of lading. An on-board bill of lading is where the carrier, the bill of lading says, we received the goods and they're on board this vessel or a vessel. Okay. Well, the contract between the seller and buyer may not distinguish or require an on-board bill of lading. So the fact that the seller delivers the goods to the carrier and gets just a delivery bill of lading, but not an on-board bill of lading, and the goods are just kind of sitting there in the seller's warehouse, may not be a breach of the contract between the seller and the buyer. So the buyer would not have a claim against the seller because the goods were not on board a vessel yet. But if the letter of credit says, you will deliver to us an on-board bill of lading, failure to deliver that particular very specific bill of lading would be grounds for the issuer to deny acceptance of the letter of credit. Strict compliance. Everything has to be correct down to the nth degree. Now, of course, having said that, and that being the law and have been the law forever, we know that somewhere between 40 and 45% of all presentations to banks on letters of credit, when you have all those documents, will have some discrepancy somewhere. It's a very high percentage. And generally what happens is that the issuer will contact the applicant and say, will you waive this discrepancy? And the applicant can or cannot, and then paperwork goes back and forth because obviously the issuer is going to have a paper trail for that. But those delays kick in all the time. And if you look at the law that governs letters of credit, that's built into the law. If let me show you. Here we go. Letter of credit law, to the extent that it's law, is very interesting because to a large extent, it's law only by custom. And what we see here, the United States, for example, actually has a statute that governs letters of credit. It's extremely unusual, extremely unusual. Letter of credit law, the basic principles of letter of credit law have been the same forever being like 400 years. And most countries don't have letter of credit law. There's not really, I say not really, there isn't an international convention that governs letters of credit. It's all done by custom and practice. It's so understood that these rules exist and what the rules are that we just live by them. Now, when I say custom and practice, right here, did I, let me get my, okay, here we go. The International Chamber of Commerce is a private organization in Paris. And they have, over the years, promulgated several sets of rules that are adopted by parties. For example, shipping terms, standard shipping terms, CNF, CIF, FOB, those things will be in the Incoterms. But for purposes of documentary exchanges, for letters of credit, there's, and the latest is the UCP 600, and before that was the UCP 500. and this, that, and the other. This is the UCP 600 is it reads like a statute. But it's not a statute. But it lays out generally accepted, understood rules and norms for letters of credit, and often parties will put in their agreement that this is governed by the UCP 600 or whatever. But even if the parties don't put that in, it is generally recognized that these rules govern. Now, what are these rules? And these rules are the basic principles that I've been laying out for you for letters of credit. But this is so well understood in international commercial law that we don't need a convention. Everybody knows that the autonomy principle exists. Everyone knows that strict compliance is part of the structure of letters of credit. Here is a letter of credit. And you can see the first thing you notice about a letter of credit, always seems to me the first thing you notice is that it is in fact a letter. And it lays out the terms. Tells you all that you deliver this, deliver this, deliver this, deliver this, deliver this. And if you comply, then we, Bank of China, will pay whatever it is that you're required to present. It's usually a bill of lading and some payment mechanism. I tell you that it's low risk, I mean, there's always some risk, but one of the reasons why letters of credit from the issuing point of view are treated as fairly low risk is for this reason. If I go, so I've got the seller here. And the seller has to deliver all these documents, but let's just say the bill of lading, and deliver it to the issuer. The issuer has the bill of lading. The issuer has the goods, the right to the goods. They own the goods. And when they go to the buyer and they say, you pay us, you buy that bill of lading. If the buyer, and of course the issuer should have already arranged a guaranteed payment, but the issuer now is the owner of the goods and they can dispose of them if the buyer doesn't take them. And so it's not like a credit situation where the bank loans you money and hopes and prays you'll pay it back. The issuer pays the seller, but the issuer gets the goods in return. And that's why letters of credit are traditionally considered fairly low risk from the point of view of an issuing bank. Now, one of the things to keep in mind is a letter of credit is not a guarantee. Now, what do I mean by guarantee? Sure. When a bank issues a letter of credit, in a traditional commercial letter of credit like this, the bank's not saying we will pay if the buyer doesn't pay. It's not a guarantee. We promise that we'll pay if the buyer doesn't pay. The letter of credit is a primary obligation. The issuing bank says we will pay, period. So it's not a situation where the issuer comes in only if the bank doesn't perform. If the buyer doesn't perform. Look. Yeah. And this is just a walkthrough. I'm spend a couple minutes walking through the parties that I mentioned. Now, the applicant, of course, is the party that goes to the issuer and says, "We request that you issue a letter of credit in favor of the beneficiary." Okay. Now, the applicant in our traditional commercial sales transaction is going to be the buyer, could be the importer, but now. The credit, and I mentioned this, but let me emphasize this. The requirement for the credit for the applicant buyer to go to the issuer is going to be the underlying contract between the seller and the buyer. So if the buyer does not get the letter of credit, the buyer is in breach of the contract, breach of the sales contract. And that kicks in a couple of things. First of all, keep in mind that the seller is not going to ship the goods until the letter of credit has been issued, and the failure of the letter. So the seller's protected in the sense that the seller's not going to ship the goods until they have this guaranteed payment. But irrespective of the fact that the seller retains the goods, doesn't ship them to the buyer is in breach of the contract, the contract of sale, because that's going to be in the contract. And we notice in the letter of credit, of course, it's going to say that the beneficiary, upon presentment of compliant documents, strict compliance, okay, issuing bank. And again, this is the bank. The applicant goes to the issuing bank, and the letter of credit irrevocably promises to pay against presentation of complying documents. There are in the world today revocable letters of credit, but their use is of basically no utility. The presumption is letters of credit are irrevocable, and what that means is that once the issuer issues the letter of credit, they can't cancel it, and the applicant can't go to the issuer and say, "Cancel that. We want it revoked." Because that takes the utility of the letter of credit away. We want these letters of credit to function in such a way that the beneficiary, the seller, has a guarantee that it's not going to disappear. As I mentioned, the confirming bank, if we have a confirming bank, now the confirming bank, of course, takes on the obligation of the issuing bank, and therefore, as I mentioned, the issuing bank is obligated to pay the confirming bank, and that should be self-evident. And of course, the issuing bank is going to retain the documents until paid by the applicant buyer. So, they're dangling those documents out. Come pay whatever the charge is, the contract price or whatever expenses, and we'll give you the bill of lading. So that's our issuing bank. And then the confirming bank. Now, as I mentioned, there's a local bank can function either as an advising bank only, or a confirming bank. And it's interesting when you look at these standard confirmation advising letters, the way you can tell, I always have examples that I use in class, and I said, you can tell whether this bank is an advising bank or a confirming bank, because there are little boxes there that you check. You check one, it says we're an advising bank, and if you check the other ones, we're a confirming bank as well. Now, because the issuing bank is responsible for paying and will only pay on presentation of documents that strictly comply, the confirming bank has an obligation to verify the compliance. Because if the confirming bank pays on the documents and it gets to the issuing bank, if they're not complying, then the issuing bank can reject the documents and properly refuse to pay the confirming bank. there's a lot of document checking here that's obvious, and everything has to be in its proper form. But to a large extent, that's not much of a problem for most banks because most of these documents are fairly standardized documents that one could read and see whether they conform or not. So the people in the banks that are doing this paperwork, this is what they do, and they know how to do it. Yeah. I mentioned this, and I'll mention it again. The principles of letters of credit, not just the major principles I've been discussing, like autonomy principle and strict compliance, but the timing, how much time a bank has to examine documents and to reject the documents or to accept them. And that'll all be in the UCP 600 or whatever other source that the parties are using. But this is all by custom and trade to a large extent. All the players understand what the rules are and they know how to play. And that's what this little quote here is telling us, is that we know what the obligations are. These are just some principles from the UCP 600 that govern that. The one that I want to emphasize is this one here. Banks deal with documents and not with goods. A bank's obligation, confirming bank or an issuing bank, when they're examining documents to see whether they conform with the terms of the letters of credit, they're obligated to make sure that documents conform. They don't, but whether the transaction that it's based on, whether that conforms or not, is all that banks don't deal with. I'll give you an example. There was a letter of credit that required a bill of lading for Coromandel nuts. And it didn't say Coromandel nuts, it said Brazilian ground nuts. And the bank rejected it. The applicant went and said, wait, why did you reject it? And the bank said, because the bill of lading said, I didn't say Coromandel nuts. And the applicant, the buyer, said, they're the same thing. And the bank quite rightfully said, and this is a major international lawsuit, the bank quite rightfully said, it ain't our problem. It's not our job to understand these trade terms and these trade usages for the trade of the goods. Our job is to understand banking practice and banking trade. Whether the services or the performance of the goods are complying or not, whether the bank doesn't know and doesn't care. They only deal with the documents. This principle here, Article 15, is a sort of the Grundnorm of a letter of credit. When the bank determines that the documents comply, when the presentation being the term we use for literally presenting the documents, when the presentation is complying, they must honor the letter of credit. They have to pay. And now that is the again the essential function here of letters of credit. The seller and buyer can have all the fights in the world they want, but the bank has to pay anyway. So the seller doesn't take the risk. The beneficiary doesn't take the risk of any disagreement between the applicant and the beneficiary. That's a different commercial transaction, and the seller gets paid anyway. I mentioned this in the credit. It's credit. We're talking about the letter of credit is separate from the contract, and it's important to keep that in mind. And I am going to emphasize, if I might, a point that I think I've said 2 or 3 times already, and I'm going to say it again. So I think it's very important that we appreciate this aspect of the relationship. Okay, if I've got the seller and I've got the buyer, they have a contractual relationship, and that contract lays out their obligations. But that's between them, and nobody else is responsible for that. So we have an agreement with a carrier. And carriers have liability, not just the bill of lading that we've discussed, but carriers have other liability. But if there's a problem with the carrier, that's based on the contract of carriage and in the law of carriage. It has nothing to do with this underlying contract. Now, if we're dealing with banks that are delivering documents, and this is a very important part of banking, international banking business. So that, the moving of the documents, that's based on banking law and banking practice. And if there's a problem here, they lose the documents, or the presentation is improper or something. That's banking law, but it doesn't have anything to do with this or this. Now, our letter of credit transaction is governed by letter of credit law. And if there's a problem with the letter of credit, the issuer doesn't properly pay, or the documents don't conform as they're supposed to, that's a problem between the issuer and either the applicant or the beneficiary. That's based on letter of credit law, which is separate from the banking law of delivering documents, which is separate from the underlying contract between the seller and buyer, which is separate from the agreement the carrier has with these parties. And so always keep in mind when you have a breakdown, if there's a problem in this overall transaction, where's the breakdown? Is it with the letter of credit? Then look at letter of credit law. What are the rights and obligations? Is it with the delivery of the documents, the payments going back and forth? And look at your banking law, look at your underlying sales contract carrier. But don't mix and match. Don't mix and match, because each of these parties have their own legal obligations and responsibilities, and they're only responsible for that. Which brings us back to don't confuse the letter of credit with the underlying contract, and that's the point here. And from that, we derive what we've been talking about as the independence principle. An issuer on a letter of credit is only responsible for complying with the rules that govern letters of credit and the terms of the specific letter of credit. And they're not interested at all in the underlying contract because they don't need to be interested. It's not within their legal purview. Okay. Now, are there circumstances when the issuing bank can avoid payment? And the answer is yes. Yes. And the most obvious basis for rejecting a presentation of payment is when the documents don't strictly comply. But there is a very, very limited situation where a bank can avoid payment, and that's based on fraud. Now, fraud covers a lot of territory here. If the this gives you the amount of time that a bank has to examine documents. So yeah, you don't have to do it instantaneously. You have some time. But what are you examining? What are we examining? What we're looking for is whether the documents themselves comply. And there's a couple of types of fraud that might be raised, and that's fraudulent documents, forged documents, and fraud in the transaction. And this is, okay. Okay, and it's seller and buyer. And we're going to come back in a second to a fraud here in the underlying contract. But what I'm interested here initially is the issuer gets the documents. Now, fraudulent documents are documents that are just totally made up. It's a fake bill of lading or this, that, and the other. A forged document is a document that has been changed. So, the 10,000 becomes 100,000, that sort of thing. Okay. But they're effectively documents that are not legitimate in the way that they're supposed to be. If they appear on their face to conform, the issuing bank has to pay anyway. There is an exception, though. If our applicant has reason to know that the documents are fraudulent or forged, then the applicant can get a court injunction to keep the issuing bank from paying. So the issuing bank has to pay if they look on their face to be legitimate, unless the applicant gets an injunction to prevent the payment of a fraudulent or forged document. That's a wonderful theory, by the way, because it's very rare that an applicant would have advanced knowledge of a fraudulent or forged document. But that is those if the documents themselves are not proper. Now, if it's clear on their face that they're fraudulent or forged, then there's no compliance and the issuing bank doesn't pay. But in the case, in a situation where they appear to be proper and the issuing bank has no reason to know they're not, then the applicant has to get a court injunction to prevent payment. Otherwise, the issuing bank is required to pay. Okay? Now, that's fraud with fraud, and I'm putting forged documents in the same category as fraudulent documents. That's the fight with between the obligation of the issuing bank to pay on the documents themselves, because that is the basis of the issuing bank's obligation, is to pay on the documents. Now, what about a fraud in, and this is where the cases become somewhat interesting, I think. What if there's a fraud on in the underlying contract? So seller and buyer. And let's say that the seller sends non-conforming goods. Now, the seller and buyer have a lot of reason to go at each other, but let's just assume that the goods are non-conforming. The buyer has a cause of action against the seller. You sent non-conforming goods. I sue you for breach of contract. Now that's fair. You can sue for the breach of contract, but that's not normally the buyer's problem. The issuer's problem. If the documents conform, we pay, and you fight out that fight between yourselves. But it's not our job. In fact, the whole purpose of letters of credit are to guarantee payment, irrespective of the fact that there may be a conflict between these two parties. There is a limited exception for what we call fraud in the transaction. And fraud in the transaction is a fraud in this agreement. As a general rule, it's not a defense to payment on the letter of credit. However, in certain circumstances, very limited circumstances, we will allow that. Let's see. I think I have a quote. Here's a general rule. Oh, wait, I'm sorry. I've got to switch my screen sharing. Here's a general rule, again, out of a famous letter of credit case. It should go beyond documents and present the buyer's request. Court will not require or permit the bank to delay paying the drafts which are proper in form in conforming to the terms of the letter of credit. However, if the situation is such that, say, the seller sent the boxes that are supposed to contain the goods, sellers, they're empty, or they just fill it full of garbage, so that we're not talking about non-conforming goods. We're not talking about a lesser quantity than what's required or something like that, but a situation where the seller would have no reasonable expectation that under any circumstances the seller could be paid. In that case, the buyer, again, the seller will pay on the letter of credit unless the buyer gets an injunction against the issuing bank to pay. Now, how would the buyer know? Sometimes the letter of credit will say, you present these documents to us and we will pay you, say, in 30 days or 60 days. Now, that's an absolute obligation to pay, but it's a delayed obligation. And the purpose of the delayed obligation is maybe to allow the buyer to take possession of the goods and resell them, and that allows the payment to flow back at a later time. So it's effectively a credit sale, but it's not really a credit sale because the issuer has guaranteed payment in the future. But in a case like that, the buyer might know that the goods are defective or non-conforming. The buyer doesn't want to pay. But mere non-conformity is not a problem that is the issuer's problem, because again, what we've done is shift the risk from the risk of non-payment away from the seller. The seller gets guaranteed payment irrespective of any dispute in the underlying transaction. But in the rare case where what the performance the seller has rendered is so deficient as to effectively be no performance, there is this limited exception there of fraud in the transaction where the applicant can get a court injunction to enjoin the issuing bank from paying on the letter of credit. Those cases are few and far between, because again, the sellers and buyers having lawsuits, having disputes over the quality of the goods, the performance of is common enough. And again, to emphasize this, it's not within the purview of an issuing bank to be involved in that transaction. There's a case out of Virginia that I teach my students, and it was a dispute, and the question was whether the bank had paid on the letter of credit, and the court even noted in the decision that the seller and buyer had come to an agreement. They had settled the case out of court for the underlying transaction, and the court mentioned, and we have no idea what the terms were because it was a confidential settlement. But the court emphasized they didn't care how the suit between the buyer and seller was resolved because it had nothing to do with the bank's obligation to pay on the letter of credit, which the court said they had. Anyway, so that pretty much covers what I'd hoped to cover. So with that, I will finish my end here. Other than I'm happy to entertain any questions, comments, concerns, complaints. Do I see a hand?
Yeah. Yes, Henry, I see several hands here, and I actually 1, 2, 3, 4. You have 5 hands.
Wow. Okay.
So I begin. Here's the first question.
Quite a different lecture, the Rotterdam rules were mentioned.
Yes.
That only 3 states were members. Is there a reason? So is it somehow a disadvantage to be a member state of the Rotterdam rules, or what's the reason?
The question was, you mentioned that only 3 contracting states have ratified Rotterdam rules so far, and the question was, do we have an explanation for that? Is that disadvantageous for a country to ratify the Rotterdam rules? I should mention that the next lecture will be on carriage of goods, and that perhaps there will give us an opportunity to explore that further. But maybe you could give your take on that quickly, Henry.
The problem, it's not really a problem. The situation with the Rotterdam rules is the situation we have with so many international treaties and conventions with international commercial law. Keep in mind that the most successful international commercial treaty is probably the New York Convention, the enforcement of arbitral awards. It took 20 years to get countries, a large number of countries to ratify that. And so there's the tendency that these things take a long time. But with the Rotterdam rules themselves, I hope these slides can be shared with you. The problem with the Rotterdam rules per se is that they're competing with several other conventions, the Hague rules, the Hague-Visby rules, etc. And so because there are all these other competitive regimes out there, and many countries have already adopted them, it's a hard political push to convince a country that they need to adopt a new convention when they've already adopted a convention. They already have rules that govern basically the same circumstance. Parties adjust to it. So if I'm dealing with the Hague-Visby rules, because it's contracting parties, I know what the rules are, and so I know how to accommodate that. So I think that's really the problem with the Rotterdam rules is it's an attempt to update existing rules and dealing with electronic bills of lading. There's a lot of good stuff in there, but it's hard to get political will for countries to change their existing law. Is my take on that.
Yeah, and if you allow me to add something to that also, Henry, I would add that the existing carriage conventions are concerned mainly only with the liability of the carrier for loss or damage to the goods during carriage. The Rotterdam rules are the first attempt in 70 years to codify all the rest of carriage of law, which is not written in any convention, including the aspects that Henry Gabriel was addressing today, the value of the bill of lading as a document of title. And all this is not codified anywhere. It's all practice and court precedent. That makes the Rotterdam rules a very complex instrument. It has 90 articles. And the Hague-Visby rules have, what, 20 or so? So that also adds to the complexity. And there is one other element to that, is that the Rotterdam rules for the first time introduced the notion that you can waive your liability to a larger extent that is possible under the mandatory conventions. So-called notion of a volume contract, which is kind of innovative, meaning if you're a big company, you are in a position to negotiate favorable terms with the carrier, you should be allowed to negotiate everything. And that is a novel concept to many countries. Some also still need to digest that idea.
Yeah.
Okay, second question.
Can I take off the mouse?
I think we are far enough from everybody else. And if your neighbors are not concerned.
Because my question is concerning the last hour, basically. So
yeah.
Thank you for the legal for the explanation. Legally, it's completely clear for me, but I have a problem with the economic standpoint, because you described the problem that this construct helps the seller. But I still don't get why the buyer would get into this contract or this construct, because he goes basically into an absolute obligation. And there is no way to, when there is contract disputes, as you said before, without, if they're not on the level of fraud, that he has to pay the price. And I still don't get it why the buyer would do it. And are there ways to make it better or easier for the buyer to get out of this?
I think I can safely summarize the question without compromising the content. And the question is simply, what is the advantage for the buyer to get into a letter of credit business? I mean, it seems from what you explained, it protects the seller gets paid, the bank has an unconditional obligation to pay, but what is in for the buyer?
It's a great question. If the buyer, there is the risk of a conflict, but letters of credit not only guarantee the payment for the seller, but they allow a lot of other smoothing of risk, because they're going to be set out in a given currency. So you get rid of currency exchange rate problems. You get rid of currency fluctuation problems probably as well, when you add the letter of credit along with the bill of exchange and this, that, and the other. But the other thing is that the buyer is asking the seller to commit to transporting the goods halfway around the world with no guarantee that the seller is going to get paid. Now, if the buyer is credit worthy or has the wherewithal to pay, that is going to, the issuing bank, the local bank for the buyer will respect that. So the buyer, can sort of guarantee payment without having to say, I promise I can pay. Yeah, but the seller's not going to ship the goods without it, is really what it comes down to. Is there's generally a power imbalance. The seller says, I don't know that I can ship these goods unless I have a guarantee. In the end, the dispute is going to be resolved as it's going to be, but it does take the, you and I can have a dispute, but if the money's in my back pocket, I'm not as worried as if it is in your back pocket. If the buyer could avoid the letter of credit, but remember, what risk does the buyer have? If I'm shipping oil, grain, something of that nature, it's going to be inspected before shipment, and I'm going to have an inspection certificate that guarantees the quality of the goods. And if the goods are not as they're supposed to be, then I have a claim against the bonded inspector. So to the extent that the buyer can put the buyer in a position to not worry about the quality of the performance, then it probably doesn't matter.
Yeah.
But in the end, it's a power imbalance. That there's a fundamental risk that the buyer assumes, and the seller's off the hook for.
And again, also, if I may also add, Henry, you mentioned that when you're explaining the notion of strict compliance and the documentary nature of the credit. If you're a buyer and you use a documentary credit, you know that the seller, before it gets paid, it must prove that it has shipped, and it must prove that the goods comply at least formally with the contract. So they would have to have delivered the goods to the carrier. The carrier would have issued the bill of lading that says, I received so many pallets.
Yep.
Either said to contain, or the carrier has indeed already expected, right?
Yes.
And that already protects the buyer, because the buyer is otherwise, without a letter of credit, the seller would say, I want the money
up front.
And if the seller is the weaker party, the seller will have to pay in advance without an opportunity to inspect the goods, unless you pay someone or you have an agent in the port of loading that is there and inspect the goods. So it does help both parties at the end. Let's go zigzag. We have one question in the back.
So you put up the quote of the United States merchants against the Royal Bank of Canada. And my question was, if I understood this right, he said that there are 4 independent contracts which are interconnected with each other. My question would be, if along the lines one of these 4 contracts is affected either by an act of God or by some externality, how will it affect the other remaining 3 contracts? Will they also be frustrated in some way?
Our British colleague in the room was very touched by your quoting Lord Diplock, Henry, and he's asking you, and that portion of that famous judgment, Lord Diplock stresses the independence and autonomy principle of the various, the 4 basic obligations, the letter of credit structure. And his question is, what happens to the other 3 contracts if one of them is disturbed, for example, by an act of God or force majeure or frustration? What happens to the other obligations?
They're going to be governed by something else. So act of God, boat goes down, boat sinks. Somebody's going to be going after the insurance company because risks like that, acts of God, are inevitably going to be insured. You don't ship goods of any value without having them insured. So the assumption would be the issuing bank is going to pay on the documents if they're presented. You say even if the goods don't arrive. But that, for example, say goods being lost, that is an allocated risk in the underlying contract. So between the seller and the buyer, generally speaking, the risk of loss, so acts of God, goods being lost, is going to be on the buyer. The buyers assume that risk in the underlying contract. Now, I assume a risk like that, then I try to mitigate the risk, and so the contract's going to require the seller to procure insurance for the shipment of the goods, for the shipment of carriage. And so the buyer, say, for example, should be protected there. However, as between the issuing bank and the buyer and the seller, it's not the bank's problem. Did that respond to your question? Did I properly?
Yes, and on the top of it, Henry, if the act of God affects one of the banks, the other bank has to pay.
Act of God affecting the bank. Oh yeah, well that's a different.
One of them goes bankrupt, the other has to pay because they're jointly liable for that.
Absolutely. In the case of the issuing bank and the confirming bank, I always remind my students that the only real risk you have is the bank going insolvent. But of course, it is a risk. And if a confirming bank, for example, has confirmed, they have to pay even if the issuing bank cannot reimburse them. But nothing's foolproof. But generally speaking, Bank of America is okay with Bank Austria. Yeah.
Yes.
Yeah, my question is also concerning banks. So my question is the following. Can each bank potentially be an issuer of the letter of credit? So are there some requirements for the constant bank to become the issuer of letter of credit? So yeah, I mean, each bank all over the world be an issuer of letter of credit, or there are some requirements to become an issuer of letter of credit.
So our colleague, and we didn't quote any Ukrainian judgment, so there is no other background to that. But just asking you whether any bank free to issue letters of credit? Can any bank issue a letter of credit, or any requirements for banks to be in that business?
No, that's a wonderful question. That's a wonderful question. Any person can issue a letter of credit, in theory. I could issue a letter of credit, but nobody would rely on it. But okay. But going back to banks, what happens is generally accepted international commercial norms are that it has to be a known reputable bank. Now that's not a requirement in letter of credit law. That's a requirement in for example, sales law. And that's just so within the contract between the seller and buyer, for example, that's going to require the buyer to get the letter of credit. Implicit in that contract is the requirement that the issuing bank is a reputable international bank. Now, if a small bank issues a letter of credit that somehow is not a reputable international bank, they would be expected to have a confirming bank that met that requirement. So any bank can issue it, but by commercial practice, it has to be a bank that is internationally reputable, whatever that means. But I say whatever that means. Obviously, it has some content. Does that answer your question? It's a great question.
Yeah, and I think it's a good question for them to remember. Last time when they talk about conformity of goods under the CISG and fundamental breach under the CISG, and one of the examples they heard from case law was the refusal by the buyer to issue a letter of credit that meets the requirements of the seller. And
yes.
If the seller makes that an essential term of the contract, the refusal by the buyer could be a fundamental breach. Exactly the point that you are making about the reputable bank. This sounds like a much more exciting topic than the CISG, Henry, because you have many more people asking questions today. Next question, please.
I want to clarify one issue. So, according to the principle of independence and when it has letter of credit, is it enough for bank to make a payment to the seller, just documents received from the seller side that this buyer's side has to be also received. Because in this case, if a buyer, if something happened with the goods on the sea, it means that a buyer will not give the documents to the bank.
There's a very quick answer to that, but I think Henry would give a better answer anyway. The question was, is it enough for the bank to effect payment to receive the documents provided by the seller, or is also the buyer required to deliver documents to the bank, you know, in case, for instance, there is damage or loss of goods during carriage?
Are we talking about on a letter of credit?
Yeah.
The applicant doesn't normally deliver. There's no reason for the applicant to deliver documents. The letter of credit is issued in favor of the beneficiary, the seller, and it's the seller's obligation to meet those requirements so that the seller can get paid.
So it's enough only from seller's side.
Yes.
That he delivered the goods.
Yeah, the question is it enough for the seller to tender documents that prove that it has delivered the goods?
Yes and no. The letter of credit is going to specify the particular documents. So, for example, one of the documents is likely to be a bill of lading. Now, the bill of lading is only going to specify that the seller has delivered the goods to the carrier, and so delivery in that case, I mean, your normal contract of carriage between the buyer and seller, the seller has delivered goods and met the seller's contractual obligations when the goods are delivered to the carrier. So the bill of lading indicates delivery of the goods. Okay, so the goods don't have to get to the buyer for there to be delivery, but it would be very unusual that that document alone would be all that would be required under a letter of credit. There's going to be a variety of documents. So it's going to be delivery of the goods, insurance of the goods, customs clearance forms, et cetera, et cetera, et cetera. Did I get the question correct? Is that the?
But basically, it's enough to have documents only from seller's side, right? So for bank, in order to give payment, to give also some money to the seller is enough to receive documents from the sellers that he received, that he did all his contractual obligations. The bank doesn't require any documents from the buyers that he received, right?
So sure, again, confirming that all that is required are the documents by the seller, proving that the seller has complied with its obligations under the sales contract, and that the bank would not be asking for documents from the buyer.
That's correct. One qualification: the seller has to comply not necessarily with the requirements under the sales contract, but the requirements of the letter of credit, which could be at some variance from the sales contract. In other words, the seller's obligation for purposes of the letter of credit is to comply with the letter of credit. Now, that's going to refer, of course, to a good chunk of the sales contract. There could be obligations in the sales contract. The seller could have obligations to the buyer under the sales agreement that would not be reflected in the letter of credit, and the bank would pay anyway.
But I mean, that obviously also refers to the documentary credit structure, because in practice, the bank would practically never issue a letter of credit to an applicant who is not himself a client of the bank, because the bank would also be relying on your bank account as a security in
Yes.
case, I mean, for your payment, right, against delivery of the documents.
Sure.
Now, another question?
Is this such a thing that's because we have the guarantee that you're saying it's not a guarantee, like if there's something that's like, does the German or Austrian law know something as a letter of credit?
Henry, I think I'll pick up this one because it's about German and Austrian law.
If you would.
Akkreditiven. This is the term we use. This is the term we use here to refer to these transactions. Yes, please.
My question would regard the nature of the LSU itself. So we've heard that the credit itself is of a non-contractual nature, but would, for example, the agreement between two banks to just generally confirm different letters of credit, would that in turn be a contract, or would that also be something of the sui generis nature of the credit?
Can you rephrase your question? Because I don't think the Professor Gabriel ever said that it's not a contract. These are all contracts.
Yeah, but I'm still having troubles wrapping my head around about that whole non-contractual nature of the credit in itself, or maybe just to iterate on how precisely I can understand this credit.
Well, I suspect, Henry, there might have been a minor misunderstanding here when you refer to non-contractual nature of the letter of credit. You certainly didn't mean that the letter of credit itself is not a contract. You meant that the letter of credit is unrelated to the relying contract. And
Yes,
perhaps if you could then restate that.
Yeah, what you see, you probably would interpret the terms of a letter of credit the same way you would interpret a contract or something. That's an interpretation question. My point was that a letter of credit is a legal instrument, is not in and of itself a contract. It's a letter of credit, and therefore it's governed by the law of letter of credit. You don't impose contract obligations and contract defenses to a letter of credit. You apply letter of credit obligations and letter of credit defenses. It's its own little legal instrument. So it's a mistake to treat it as just a simple contract relationship, I guess is my point. There's always little contract parts floating in there. There's going to be a contract between the applicant and the issuer to issue the contract. There's going to be maybe a contract agreement between the confirming bank and the advising bank, but there doesn't really need to be. But my point is to treat a letter of credit within its own little legal sphere, and not treat it as one would a simple contract relationship. Is that responsive?
Yeah, and also in other words, also if I may also jump in, Henry. In other words, what they're talking about here is that the term letter of credit refers to this document, right? This piece of paper that contains the conditions for payment. And then we often talk about letter of credit referring to the entire transaction. But that transaction consists of 4 different contracts.
Oh, yeah.
And what Professor Gabriel is saying, you don't treat the letter of credit as one single contract. There are 4 separate contracts in a bundle. And my contract as an applicant with the bank that issues the credit is different from the contract between the bank and the confirming bank. And again, that is different from the contract between the confirming bank and the beneficiary, but they're all parts in a single bundle of contract. We have 2 more questions.
Okay.
In the back, please. Sorry. Yes, thank you.
What if the delivery of cargo is requested without presentation of the bill of lading or clearing? Is possible?
The delivery of cargo without.
What if delivery of cargo is requested without presentation of the bill of lading?
Who requests the delivery of cargo?
Like
at the port of destination.
Yes, at the port of destination. What if like if you do it, can you, is it necessary, is it mandatory, compulsory, like show the bill of lading when you use it?
That's an easy one, Henry. I think we can talk 45 minutes about that one. Is it getting back to bills of lading? Can you obtain delivery of the goods without a bill of lading? That's essentially your question, right? And under what circumstances?
If it's a negotiable bill of lading, the answer is, can you get the goods from the carrier? The answer is no. Are there any exceptions? None worth noting. With a non-negotiable bill of lading, which is simply a contract for carriage effectively, then you don't need the piece of paper generally. But with a negotiable bill of lading, the answer is no. The carrier will not deliver the goods without the bill of lading because they incur liability. If the buyer said, I only want to come in and it's, they're there in storage there, I only want to come in and inspect the goods, but I don't want to take delivery, the carrier is going to say, absolutely not. You show us the piece of paper. Misdelivery is the term.
Misdelivery, right?
And it's a big no-no.
And and unfortunately, the thing is, the carrier should not deliver without the bill of lading. But in practice, we know there's a very bad practice around the world that is invented by British lawyers, of course, like most in the world. And that is delivery against so-called letters of indemnity. That is, you lost your bill of lading, or it got stuck in the mail.
Oh, yeah.
Right? And the ship is already there, and the captain is in a hurry to leave the harbor because it's paying the merge per day, occupying that slot in the harbor. Right?
In that case, you get a letter of indemnity saying, if you suffer any loss, any harm, we indemnify you.
Yeah.
One of the things, and I mentioned the standard containers, they all come, the millions of those things all have barcodes. And one of the ways that we show the bill of lading is we roll in with the truck, we punch in the magic number, and you can drive out of the locked area where the carrier keeps the goods if your secret code scans the barcode. So you're not going to get out unless you know the magic numbers, and you don't get the magic numbers unless either the issuing bank or somebody's giving you the magic numbers. Anyway.
We had one more question. It was you?
I got a short one.
Yeah.
It's basically who is paying for the letter of credit? Is it the buyer or the seller?
Who's paying for the cost of the letter of credit?
Well, the upfront cost is going to be the buyer, because the applicant goes to the issuer and says, we need this letter of credit for the beneficiary, and the applicant bank says, okay, fine, here are the fees. So the buyer pays upfront, but it's like a lot of other costs. All of the costs are going to be allocated somehow when we figure out other costs. But it's the upfront fees are always the buyer, not always, but inevitably the buyer, the applicant.
Any more questions? No, I think we seem to have exhausted the subject. Professor Gabriel.
Well, thank you. I've enjoyed this, and so I'm now off to go teach. I'm going to be sitting right here to teach my secure transactions class in a few minutes.
All right. Have a good course. Thank you.
Thank you. I enjoyed it, guys. Thank you.